Now call 124-804 State v. Spencer.
Morning, may it please the court. Ryan Eddinger, Appellate Defender Office, here on behalf on Micaela Spencer today, defendant appellant in this case. If I could request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. Sedgwick County jury convicted Micaela Spencer of 1 count of premeditated first-degree murder, 1 count of theft, and 1 count of selling sexual relations. The district court thereafter imposed a hard 50 sentence. There are 2 issues here this morning before the court that I would like to address, and unless the court would direct me otherwise, I would like to focus my energy this morning on the claim that Mrs. Spencer's statements, despite the issuing of Miranda warnings, were not made voluntarily due to the circumstances surrounding her interrogation. As this court knows, there's several factors to consider in this analysis. One of which, and I can just list them quickly, the accused's mental condition, the manner and duration of the interrogation at issue, her ability to communicate with the outside world upon request, the accused's age, intellect, and her background, the fairness of the officers in conducting the interrogation, and the accused's fluency in the English language.
Before you get too far down that path, can I ask you a question? Do we even need to get that far? I mean, even if we didn't take into consideration the admissions or the confessions, why isn't the other trial evidence sufficient to support the first-degree murder charges? Or where's the gap in the evidence that requires us to have to rely on the confession to find that there's sufficient evidence?
Are you I suppose in some way you're asking me whether, even if you were to, you're asking me a harmlessness question?
Yeah,
Basically,
essentially.
Is that essentially
Yeah,
what you're
yeah, I
asking?
think so.
What I would argue here is that if these statements don't come in, if this interrogation doesn't happen the way it does, and she's not put in this position, this coercive environment, a situation where she's been sleepless for well over 24 hours. It looks like 48 hours has just come off of an obvious meth fueled binge, and is given an opportunity for counsel. I think the whole framing of this entire case could be completely different. I would submit that the court's well aware of the background circumstances and the accusations that she was making, that basically all of the facts that are there, that the things she spoke about during that interrogation. And I don't really necessarily feel at liberty to go completely at length into those as they weren't proven by any means. But I think that's the critical point. I think if she has counsel and asserts her right to counsel, at that point that this case could have turned out completely different. I think she could have had, she'd get an opportunity to build some kind of defense. That
I'm not sure I follow that. And I kind of agree there's a little bit of a chicken and egg problem that I've had with this, because let's assume you lose on the voluntariness of the confession issue.
can you say it one more?
Assume you lose,
Assume I lose.
then clearly there's sufficiency, right?
You're
I think-
asking about sufficiency to support premeditation. Is that what you're asking?
Yes.
I've made the argument that there is a question here, that a reasonable jury could have looked at that and said that it was lacking in premeditation. She did explain that the original reason for this was not, there was no, I know it was the state's theory in this whole thing that, and I know Detective Palmer made it very clear that that was what she believed was the situation, that this was a planned event, that the plan was developed beforehand, well beforehand, in reaction to the trauma that my client has allegedly sustained at the hands of the victim in this case.
But let's get back then to Justice Wall's question. If we I guess I just want to know why there isn't sufficient evidence, setting aside the voluntariness of her statements. why the evidence put on by the state isn't sufficient to justify the conviction on premeditated.
Even in the you're asking me that even in the
Absence of the
absence of anything, any evidence that came in as a result of her testimony, why? Because is that what you're asking?
Yeah.
Let's pull her entire, all the evidence at trial.
All of her admission. I
All
mean,
of
but
it,
it's
pull
just
all
her
the
admission.
evidence at
You've still
trial
got a
about-
recording, you've still got, I mean, you've got a lot of other evidence here.
Yeah.
I got a lot of evidence. I'm just saying, and that's what I think Justice Wall's getting at is
And I understand the question.
is absent the voluntary, absent her statements to police. Why isn't the rest of it enough?
I would say it's like you said, it's kind of a chicken and egg problem. It's not, I would argue it's not enough because there is a tremendous amount of, there's a very first thing that a juror commonly thinks of when you get to the question of premeditation is it's planned beforehand. Well, during this whole interrogation, Detective Palmer basically elicits this idea that this, even though my client refutes that notion, she says this originally, all I was doing was going there to exchange sex for $40 in marijuana. That's what she repeatedly says during her interrogation. Well, Detective Palmer basically puts it out there and at one point is like, I know you had a plan. I know that you did this and sets it up in a way that makes a lot of sense to most people that want to hear the story. You have a beginning of the story. You have a terrible event that happens allegedly to somebody. You have the end of the story. It's a, you know, as the state argued, it's a revenge story, and that speaks to people. So I think it's problematic, or you can't pull everything from her testimony or from her interrogation, all that evidence out of the trial. And basically what you're saying at that point, Your Honor, is the video is enough. If I understand what you're saying.
Well, I'm
Because
just saying that's part of the evidence, but I think there's a lot of other evidence, but there's the exchanges of the text messages on the phone,
Right.
plus a recording,
those-
there's a recording of the killing, which,
Precisely, that's what I'm saying.
and that's coming in.
Absolutely, and I understand your point completely. What you're saying is that essentially the text, and I point out, I guess that's important, the text messages, she gave consent to have her phone searched. I would say there was no motion to suppress, but she gave consent to have her phone searched during that interrogation. And she does it in a manner where very reluctantly.
But we
let's
don't
say.
have to get to that because.
Well, I think if we're going to talk about the text messages and how they got into trial, then I
But there has to,
definitely have to talk
but we
about
have
that.
to, we have to move to suppress to make that a legal issue to.
Right,
Yeah,
but and
that's the
again,
problem.
it wasn't, I'm just saying that.
We have the
it-
number
it
of,
did
we
come
have
in
what,
that way.
14 stab wounds, I mean, there's evidence here that a jury could look at and say, yeah, that's premeditated without even thinking about her statements.
It could, but I don't know that we can say beyond a reasonable doubt that they would. Is the only response I can provide. And I think, and I do understand the question that even in the absence of everything that happened in this interrogation, but I think that's really how I have to answer the question. If this is I think this could be a completely different situation if she's able to build a defense. If she's not placed in an interrogation room at 3:33 a.m. in the morning of, what is it, I think it was May 13th. She's been sitting in that room for 7.5 hours before anybody comes in. The detective comes in at 3:33 a.m. She knows she's been up, like she said, she's seen the trailer, the accused mental state. She says she's been doing meth. She doesn't say she's acutely under the influence at that point in time. But when you watch the interrogation, there's multiple times where she sounds incoherent. She says, I don't remember. She says it was just a dream. So there's a number of factors here that I think I pointed most of them out.
She acknowledged to the officers that, I mean, I wrote them down here, she provided her biographical information, her current and previous addresses, her date of birth, her social security number, her height, weight, medical history, her mother's phone number.
All right, and those are sort of administrative things.
And what the court found to be the district court found to be in a clear and coherent manner. And our standard of review is whether, there's substantial competent evidence to support the factual findings of the, then whether the law applied to those. So,
About de novo.
and we're not allowed to reweigh the evidence. So the question is whether, looking at that tape, looking at what the officers testified to, whether there's substantial competent evidence to support the district court's conclusion. I mean, I know you know that. It's just, I think there's another side to this that supports what the district court seems to be finding, unless you've got some other reason, why.
Well, I think I'm arguing that the court actually had substantial competent evidence to toss this interrogation. And instead of allowing it to come into evidence, to suppress it and keep it from the jury. The court watched the video. The court had to see that, she made the same admissions. If the court's basing the fact that she knows her address and that's substantial competent evidence to say that she's made a full and voluntary knowing waiver of her constitutional right against self-incrimination at 3:33 a.m. in the morning from 7 to 7 a.m. in the morning. I mean, to the extent.
Distinguish this from other cases, which in my mind, over the years, we found perhaps someone who's being questioned under greater influence and maybe stumbling and then kind of regains composure. How does this fit in like the Galloway analysis and some others where there was even perhaps greater evidence of intoxication and we found it was still voluntary? I don't see this as an extreme outlier anywhere. It kind of fits in those cases.
I'd say it's difficult. I agree. And the standard is the condition has to render the defendant confused, unable to understand, unable to remember sort of what occurred. Those are the things that Galloway sort of.
Exactly. And what Justice Miles just touched on, what the court found was, certain basic questions was able to comprehend the events that took place. I'm just not seeing where it fits outside of that analysis.
Absolutely. I can address that for you, Your Honor. Like I said, and I think I'm more or less sort of repeating the same thing at this point. I apologize for that, but that's what I have here. She, those are the standards. Was she confused? Was she unable to understand, unable to remember what occurred? And I think that you have to drive it more than I know my address. I know where I'm at right now. You have to get into the substantive things of what were really the actual admissions of guilt here and what she was saying. And there's plenty of statements throughout that entire thing where she says, I don't remember. I'm really confused. Number of times where I'm so tired. I'm so tired.
And again, it fits. Those fit within some of the facts of Galloway and other cases. It just seems to me. And I understand that you're the hurdle you've got.
Right. And so that's all that I can ask the court to
let me move you to the second interview. And I realize your legal argument is the first taints the second.
Absolutely.
Let's forget about the law for a second. And just as a statement of fact, clearly is competent and coherent at the second interview because she's had plenty of time to sleep. She's been in jail. She hasn't had, access to any drugs. The evidence suggests she hasn't had anything, and she tells the same story, basically. So, as a question of whether the conditions of the first interview cause us to be concerned about the accuracy of what was said.
Well, I think it's
factually, there were no changes. Now, I understand the legal argument about free and all that stuff, but I don't want to talk about the law. I just want to talk about what does that tell us about the voluntariness of what she said the first time?
Well, I think, and I don't think how you can get around the question of taint if you're asking about the voluntariness. That you understand? I don't know how you look at it in a vacuum and compare it to the first one without that first interview having an effect of what she's saying in the second and whether she wants to talk at all. And I point out that during the very beginning of that interview, and I think this is indicative of her pretty much feeling like it is showing that from the first one, I really don't have much choice in this matter. before Detective Palmer puts the Miranda form on her and in front of her, and she just, or she can even read it to her. And so I think that's, you know, in that second interview, that's pretty clear evidence to me that this has been affected by the first one, and this is just a continuation. It's really not subsided. I see that I'm out of time, unless the court has additional questions for me. Thank you, Your Honor.
Thank you. Mr. Maloney?
May it please the court, Assistant District Attorney Matt Maloney for the state. This is a rare case, Your Honors. I think that any of us who have done criminal law for any amount of time have certainly come across cases where we have perhaps grainy surveillance footage of a murder or part of a murder, but it is extremely rare to have the quality of audio and partial video footage of a murder as it's happening. And while I acknowledge, or while I realize that counsel today didn't really argue the sufficiency argument, I think it's nevertheless important to focus to some extent on that in recapping the evidence here. We have a situation where we had overwhelming evidence of direct evidence of premeditation in this case. We have those text messages between the defendant and her boyfriend showing that this was very much a choreographed event. We have the Facebook messages that she sent to the victim for the 2 days leading up to this, that shows that she very much put this plan in place, that she was adamant that her male friend be allowed to come, which is further indication that she knew that this wasn't just going to be a sexual encounter, that she was wanting him there for help with the murder. And then, of course, we have the video and the audio of the act itself, where we hear the defendant's own words as she is stabbing and participating in a stabbing of the victim, where she is saying, go for the heart, make sure he's not breathing. Is he still breathing? Is he still alive? I think he's still breathing. So we have overwhelming evidence of premeditation even before we get to the statement. And that is to return to the questions that this court asked opposing counsel with respect to whether there would be a harmless finding if you were to find that the statement was somehow involuntary. But I want to make clear that our position, as argued in the brief, is that the district court was absolutely correct, that this was a voluntary statement. And I added the video of the interviews to the record because, first of all, it's always the best evidence when you're looking at the voluntariness of a confession or a statement. And I think it's always important when that video is clear and easily understood to have that before you so that you can press play and see exactly what was going on in that interview room. But it's also important in this case because it clarifies the timeline. And that's an important part of the defendant's argument. Essentially, the argument that the defense raised in the brief is two-pronged. One, she had used meth, and two, she hadn't slept for 2 days. And I think at one point in the brief, he even says she hadn't slept in nearly 3 days. Well, the video directly refutes that. She was brought into the interview room at 8 o'clock on a Monday night. She ends up telling the detective that she slept on Sunday night for a few hours. Now, there was initially, I think she did make some statement about a couple of days, but then when the issue is clarified, and which is why it's so important to have the video in the record, she says, oh, I slept for a few hours on Sunday night. So essentially, she had lived a normal day. I slept last night. I think that by 8 p.m. tonight, I'll be perfectly capable of making voluntary decisions. So she hadn't gone 2 days, let alone 3 days without sleeping. She had lived less than 24 hours, presumably, since she last slept. So that's one important thing with the timeline. The other important thing is in the brief, the defendant cites the 15-hour figure in assessing the voluntariness of this statement. Well, the last 3.5 hours of that can be completely discounted because all of the interview was done before the 11.5-hour mark. The last 3.5 hours is she's simply sitting in the room, not being interviewed, waiting more or less to be taken over to the jail. So the real timeline is, yes, she was in the room for 7.5 hours by herself before the interview began. Then the detective came in. There was an hour and 40 minutes of questioning. Then the detective left the room for 40 minutes, returned for another 20 minutes, left for another 45, and then came back for the final 35 minutes. Now, during that time, during those breaks, she was offered food and bathroom breaks and water on multiple occasions. The video shows, and the defendant herself confirmed to the detective, that she did in fact nap during some of the time that she was in the room by herself. So the timeline is clarified by the video. I'd also just note that simply pressing play on that video, your honors can see the same thing that the district court saw. This was not a person who was unable to make a voluntary decision of whether to speak to the officer. She was completely in control of her faculties. The defense argument is essentially that she was emotional and I think at one point used the phrase incoherent. And I would strongly disagree with that. When you watch that video, for the vast majority of the time, she is speaking about this event and about all of the questions in a very calm, organized manner. She certainly does, to some extent, try to minimize and say, well, I didn't really go there intending to kill him. I did go there to have sex in exchange for drug or money. But her own words ultimately betray her, as on a couple of occasions, she does refer to this as playing out like a fantasy and according to her dreams. So she's acknowledged that she did, in fact, think about killing him. She also, at one point during the interview, she acknowledged that when she took the knife out, she thought about where she was going to stab the victim. And then she did say that she decided to castrate the victim. So our position is that the defendant is really only focusing on the manner and duration of the interrogation. He essentially concedes that the other factors warrant a finding of voluntariness, but his position is that it's just that one factor so overrides the remaining factors as to warrant the confession involuntary. But our position is that even the one factor that defense counsel is relying on clearly weighs in the state's favor here. And as your honors pointed out, there is case law where far more extreme examples of a defendant who perhaps is actually showing signs of intoxication or drug use or sleepiness, and those statements have been found to be voluntary. And here the only reference to drugs is the fact that on the day of the murder, so now more than 24 hours earlier, that she had used meth, but by her own admission, the effects of that had worn off. And I think that's clear on the video. This was not somebody who had any trouble remembering not only the background information as far as phone numbers and her name and address, but details of the event. So our position is that absolutely this was a voluntary statement. The district court reviewed that video before making its ruling. Its findings, its factual findings are supported by substantial competent evidence, and its ultimate legal ruling is correct. So while we certainly don't believe that you need to get to a harmless error analysis because we don't think there was any error, we would also agree with some of the questions that this court asked opposing counsel. Even if you were somehow to agree that there was any problem with this statement, all of the other evidence overwhelmingly showed the defendant's guilt and showed that this was premeditated. So even if this confession were completely thrown out of court, there is no reasonable possibility that a jury would have reached a different verdict after being able to watch the video and listen to the audio of the killing, seeing those text messages, seeing the Facebook messages. The statement clearly was helpful to the state. That's why we admitted it. But even without it, even if she had gone into that interview room and refused to speak and said, I want my attorney and I'm invoking my rights, the verdict in this case would not have been different. Again, This is a rare case with the volume of evidence that we have of premeditation as far as direct evidence of premeditation. Usually you do have to prove premeditation through circumstantial evidence. But here, the defendant's own words on that audio of the murder clearly show that that element is proven. If there are no questions from the court, the state would respectfully request that the district court's ruling on the suppression issue and that the defendant's conviction be affirmed. Thank you.
Just have a couple small things that I'd like to address quickly. Number one, as far as not adding the video, or I filed a 302 to add the video from the pretrial hearing. It didn't get added, so the state had already filed its brief. So at that point, it's there either way. So that's why I didn't actually follow up on having it put in the record. Other than that, if the court doesn't have any questions for me, I'm willing to waive the remainder of my rebuttal. Thank you, John.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement.